Good afternoon. I welcome you all. Let me introduce myself. I am Isha Yaul, Head of Strategic Initiatives and Partnerships of Institute of Medicine and Law. On behalf of my organization, I welcome each one of you in this webinar. Dear doctors, every life is precious, the one which can be saved and the one who saves it. Failure to protect a doctor does not bode well for anyone, neither the patient, nor the doctor, nor the nation. On 29th March 2022, India witnessed a very unfortunate event. The suicide of Dr. Archana Sharma, a gynecologist from Rajasthan. It was undoubtedly a deliberate misinterpretation of law and a definite misuse of police power. We pray that God give enough strength to a family to cope up with this difficult situation. This tragic event could have been avoided if Dr. Sharma was aware of her legal rights and privileges in a police case, which today most of the doctors in India are not. Institute of Medicine and Law is organizing in association with API National and IMA National this webinar to help doctors understand criminal laws applicable to medical practice, the salutary protection given to doctors in cases of criminal medical negligence, and ways and means to use this legal protection. I now call upon Dr. S. Arulrhaj, past National President, API and IMA, to introduce this topic. Dr. Arulrhaj, please take over. I request Dr. Arulrhaj to please introduce this topic.
Sorry, I forgot to unmute. Thanks, Isha, for the nice words. It's our pleasure to welcome our National President, Secretary General, and three eminent past National Presidents and our API team. Our API President has to join, but Secretary has joined. Now the key doyens have joined. See, all these medical professionals are very senior people, nearly having more than 40 years of active practice. Number two, they are actively involved in the organization, and they are, actively contributing to the welfare of not only the doctors, but the society also. I'm sorry, I forgot to, introduce our, faculty here. The lawyer at Supreme Court, Mr. Bajpai, who is a very eminent senior, legal professional, whom I have listened to him. I have listened to his guidance also in some of the documents. See, now, why all these people have come here is you have given the reference. The sacrifice of, Dr. Archana Sharma from Rajasthan. Even earlier, we have been fighting on the legal side. We used to fight whether medical profession is under CPA or not. There are 72 laws and regulations on the profession today. All those things we used to talk much. But now, today, we are focusing on two things. Number one, the procedure for prosecution of a medical professional, a doctor. Even in 2005 August, Supreme Court has given a guidance that the process has to be evaluated by the Government of India in association with Medical Council of India. Earlier it was Medical Council, now it is National Medical Commission. But so far 17 years have gone, that process has not been taken up. Now we should take it up. And already with the guidance of Mr. Bajpai, I had drafted a guidelines and presented to all our colleagues as well as to the Government of India and Ministry of Health also. The second component is the growing incidence of violence. As per WHO data, 75 to 80% of doctors, not only in India, throughout the world, in US, some doctor has been fired and killed about a week ago. It is happening throughout the world. This assault or a violence can be verbal or, physical or, emotional or technical. All those things it is happening. Therefore, we need to have a right or a way to address this agenda. We have come to streets and many times we have fought, we have gone for legal fights also, but everything going on. with our fight into 2017, if my memory goes right, I mean, not 17, I mean, it may be 19. The Ministry of Health agreed for it to develop a National Healthcare Professional and Establishment Protection Act 2019. And I mean, it was a joint committee with our IMA Secretary General, Dr. Ashokan was there, and it was drafted, it circulated to our IMA people, so got the consultation from the legal side, and it was put on the Ministry of Health Family Welfare website for 30 days for public opinion. After that, it was put into, I mean, darkness. We don't know what is the reason. In the meantime, the COVID epidemic started, and we pressed for it, because even in the COVID epidemic, doctors were assaulted. Then an amendment of the Indian Epidemic Act 1948, if my memory goes right, it was done and it was in place, fairly acceptable. Now that is applicable only during durations of an epidemic. We want epidemic or not, doctors' protection is vital, because as you said, two lives are there. One is the life of the doctor and the life of the patient to be, I mean, treated. Therefore, it becomes vital. Therefore, in 2022 also we have drafted, I mean, Healthcare Protection Act based on the, previous one, which we have added two things there. What are the two things is, one is that prosecution system or procedure. The prosecution has two levels. One is filing an FIR, second is a arrest of the doctors. We have discussed that there based on the Jacob Matthew case. And a second thing is, we wanted healthcare institutions to be declared as, protected zones. Protected zones. And another addition that we have done is, I think that suggestion was given by Dr. Marthanda, that there should be a separate force. For an airport, there is a force. For many of the central government, campus, they have a force. Like that, for healthcare, there should be a separate force that should be deployed in every institution, so that the problem of the violence can be handled. These are a few things that we have already included in that. Now, with this eminent team, we will have their introductory views. Then we will listen to Mr. Bajpai on the scientific side, that is on the legal side of it. Then we will have a panel discussion. A lot of people have joined together. We will invite their questions and we will close it. The closing time should be little before 4 o'clock, because 4 o'clock we have other seminar. Thank you all. Thank you, Isha. You can take it forward.
Thank you, Dr. Arulrhaj. I would like to welcome Dr. Sahajanand Singh, National President, Indian Medical Association. Dr. Singh, I request you to speak few lines regarding this initiative and regarding this webinar.
The senior leader of IMA, Dr. S. Arulrhaj, Dr. Jayesh Lele, Dr. Prof. Marthanda Pillai, Dr. Vijaykumar, Dr. T. Ravishankar, my good friends, Dr. Munish Prabhakar, Dr. R. Sabra, and our elder brother, Dr. Vinay Agarwal. So, I am very happy that a session of Vision of India has taken initiative to discuss an important topic which is affecting our members, Prosecutions of Doctors and Healthcare Protection Act. With the session of Institution of Medicine and Law. We have been saying violence on doctors and healthcare is ultimate since many years. However, due to increased expectations by the patients and increased cost of treatment, which is beyond our control, such incidents are increasing day to day. The faulty rules and regulations put by the government and our national medical commissions have put us in a legally weak positions. Such deliberation by experts will always help us to put forth our views to the government and make necessary amendment in the existing law. Our effect should be focused on dedicated service to our patients without compromising on the safety and dignity of our profession. Sir, 15 days back, we have got a very good meeting in Ekta Nagar, Gujarat, where the Council of Nations were present. About 22 health ministers were present and chief guest by our Honorable Mansur Pandavia ji. All ministers has got one voice. They are saying the first mixopathy problem should be solved. Mixopathy, they should make a committee with the IMA people. And after 6 months, government will take decision after this committee. And violence against the doctors, they have told him we want central law. Sir, at that time, all ministers has told that pandemic, at the time of pandemic, we should change endemic for forever. This type of law we have make here in pandemic time, that all should be in the endemic forever and central law. Thirdly, we had this clinical establishment, many things we are very much alert. Our health minister is very much so nice gentleman. He has assured us within 1 or 2 months everything will be solved. We are going to on 17th. We have to meet on 19, 28 this month. And this violence against the doctor's problem will us and we have to do. So we are all are with us, sir. So this problem will be solved. I'm happy that our past president, Dr. Prof. S. Arulrhaj, has taken this initiative in conducting this seminar. Though IMA is always willing to work closely with all professional organizations, I only hope that in future we should not mind, sir, proper protocol will be followed while they involving Indian medical association. And I am saying to Jayesh Lele also, this is if any seminar, CME or webinar, so we should see the protocol are maintaining or not. So protocol should be maintained, sir. And our senior leader like Dr. Arulrhaj is our elder brother and he is the senior most leader of the IMA. He is always take care of this IMA problem. We are always with the Dr. Arulrhaj. Whatever Arulrhaj will say, we are with him. And this seminar is very good seminar, very good thing we have chosen, sir. So medical legal seminar. So we are with you, sir. Thank you very much, sir. Thank you, sir.
Thank you, Dr. Singh, for those kind words. I would now like to welcome Dr. Jayesh Lele on behalf of Institute of Medicine and Law. He is the Secretary General of IMA National. Dr. Lele, I request you to please say a few words.
Yeah, thank you, Isha. Respected National President, Dr. Sahajanand sir, President, API, all respected leaders from our IMA, Dr. Arulrhaj sir, Dr. Pillai, Dr. Vinay Agarwal sir, Dr. Vijaykumar, all past presidents, Dr. Ravi Shankar, who is also working in the medical legal field, my very good friend, Dr. Agam, Vora, and of course, Advocate Bajpai, whom we are going to listen today. This is a very important topic which initiative has been taken by Dr. Arulrhaj in designing this entire program. There are a lot of issues, two basic important issues, the criminal negligence of the doctor and the violence against the doctor which is occurring. If you see the CPA, that is a post almost 1985-86 onwards, once that CPA came into picture, both the things have started growing together. and to fix the negligence of the doctor. Who is to take care? There are a lot of, we have seen the court judgments right from Supreme Court. One of the very leading landmark, maybe Jacob Matthews and other cases, wherein very clearly how to act, how the police or the custodian of the law, basically locally in that particular situation, they should behave. What kind of evidence should be collected against prosecuting the doctors. So all those things are, but many times local police station does not follow this, and they in a to protect the patient's relatives or protect some with the help of the local leaders, so-called maybe the political leaders or maybe some leaders of that area, take the doctor to task, take the entire hospital and certain things which they land up doing, which they are not supposed to do that. Because very much procedure had been laid down. Even the NMC 2 years back very clearly stated how to form the committee, how to form the investigation committee, how to form the even the local. It will be our association level to make every doctor understand that what are his legal rights, because everywhere if you find even in the now new the NMC RNP regulation, they have mentioned about the doctor's responsibilities and patient's rights, but nobody is talking about the doctor's rights and patient's responsibility. And that is what we have been pressing in Maharashtra also. We have taken up this in the CPA, wherein the doctor's rights are also there, how to prevent this kind of errors, how to defend himself. So all those things need to be mentioned properly, and it will be this seminar will throw a very good light, and maybe a kind of a SOP can be developed for every doctor to understand that how he himself can protect himself. So that is the one portion of the basically negligence, how to see that the negligence, if it is there, and which is the authority who will take action. It is not that local police or local gundaraj or any local political leader, and in that very circumstances where the doctor is scared, because of any untoward incidents, and the crowd gathers, the violence sets in. So the violence against the doctor on the hospital establishment is another story, which IMA and collectively with the other medical associations have been fighting for long. In fact, we have been taking up at various levels last 4 or 5 years. Very active participation has occurred at the ministry level also, and I am very happy that our national president in last 4 or 5 months trying to meet the respective ministers. Give definitely a solace to all the practicing doctors. They can practice very freely at their will and treat the patient far better without the influence of this local Raj. So I think this both the things initiative which Dr. Arulrhaj sir has taken will go a long way, and I am sure at the end of it our doctors will be having more knowledge how to defend and how to protect themselves in both the situations. Thank you very much for giving the IMA opportunity to meet you all and listen to the very important advocate, and then subsequently during the question answer session as well as in the panel discussion, we will hear from our leaders more. Thank you so much for giving me the opportunity. Over to you, Isha.
Thank you, Dr. Lele, for such a beautiful summation of points. I would now like to call upon Dr. Shyam Sundar, National President, API. We are waiting for you, sir, if you have joined, because we got a message that you are trying to join. I would now like to call upon Dr. Agam Vora, Secretary General, API National. Dr. Vora, can you please say a few points about this webinar?
Thank you very much, and good afternoon, everybody. I think there is some fault at my end and the camera is not on, but it's my proud privilege to be here in front of you for this very important seminar on medical legal issues. I'm fortunate to be here with my mentors on this stage. You have Dr. Arulrhaj here, Lele sir, Shyam Sundar sir will be joining, Dr. Sahajanand Singh, and so many eminent people are there today. Medical profession was considered a godly profession once time, and it was said for those who believe in God to be the life giver or life saver. Our doctors are the personification of God on earth. It was believed by many. It was relation of a trust. Doctor was part of the family. His opinion was taken on so many non-medical issues as well, like making a will, discussing about marriage of the children, even small differences of fights in society or family would be settled in presence of doctor. But the times have changed. This is no more a noble profession. Society has now considered medical services as business, has put it under Consumer Protection Act and other acts. Trust is getting lost, and daily we hear stories about violence against. In today's time, knowing our legal stand and legal issues are as important as knowing your medical subject. And this is not only your problem, not only my problem, not only my country's problem, but trust me, it's the global problem. Most of the doctors who are practicing under some kind of fear or some kind of insecurity. And both these organizations, that is Indian Medical Association and API, have been extremely sensitive about these issues. All the people who are present here have been very aggressive on this front. We've also proposed certain points under the leadership of Dr. Arulrhaj to the authorities. And it's the time that each one of us gets aware about the rights. There cannot be any better time to discuss all these, and that's the gist of today's meeting. I've had a program with Bajpai months ago when we were talking about telemedicine and legal. I'm sure today's program will clear a lot of myths, bring facts that will help us improve our practice. Along with him, I see a galaxy of influential guests as faculties, as panelists. So get set. Next 2 hours are going to be academic bonanza. I wish you all a great time and a compliment Dr. Arulrhaj for organizing this meeting. Thank you. Over to you.
Thank you, Dr. Vora. I appreciate the way you started, like how the doctor-patient trust has to be there and how it is today and how a doctor should be able to enlighten himself on legal education. Thank you. I would like to now call upon Advocate Mahendrakumar Bajpai. He is India's leading authority on medical laws, a practicing counsel of the Supreme Court of India, and honorary director of the Institute of Medicine and Law. I request Bajpai sir to please continue.
Thank you, Isha. Leaders of IMA and API. At the outset, I'm very happy to see the face of my very dear friend Ravi Shankar. Hi, Ravi. I will keep my talk brief because I was not knowing that Dr. Arulrhaj has worked so much on a few inputs that I have given. And it would really be great to be involved, to be a part of this exercise. As advocates, we just analyze and dissect law. But what law would be necessary? And this again, not coming from the legislature, coming from the ones who are directly affected. It would be great to be a part of this panel discussion. I'll learn a few things. I straight away take you to the presentation. Isha, my screen is visible?
Yes.
Isha, my screen is visible?
Yes.
Okay. So friends, straight away, what is negligence? In the eyes of law, let us understand it. We all know what is negligence. In the ordinary parlance, in the eyes of law, it is carelessness which becomes punishable. It is a wrong. And not only in India, all over the world, negligence is both a civil wrong and a crime. One very interesting aspect of negligence is that there is no intention to do wrong. Friends, by definition, it is carelessness. Every day in our life, we are careless at some point or the other. So there is no moral fault, very basic law. And that is why courts, both civil courts as well as criminal courts, are very hesitant to punish negligence. Question often comes, then why is the negligence punished? Public policy. If a negligent conduct is not punished, it is going to cause more harm to the public. So that happens to be the only intention. Rather than punishing the wrongdoer, why negligence happens to be a wrong. Friends, another important aspect. I have already shared with you that negligence is both a civil wrong and a criminal wrong. So when does a negligent act becomes a crime? And the law on this aspect is absolutely clear. It is only when the negligence is gross, big magnitude, it is recklessness. Only in that condition, the victim can approach the criminal courts. Otherwise, there are other options. In case of doctors, this proposition applies. And so only when a doctor is grossly negligent, is reckless, this charge of criminal negligence is attracted, not otherwise. Otherwise, the patient can sue the doctor in a civil court, a consumer court, before a regulator, before High Court, before Supreme Court, even before the Human Rights Commission, and we all know that. One more clarification. It's very simple. Fees has no role to play in attracting criminal liability. Today is the age of consumer liability. So doctors are sued. 99% of the doctors are sued under the consumer laws. Their fees has a role to play. But under criminal laws, whether you are working in a government hospital, whether you are working in a charitable hospital, there is absolutely no role for fees. If you are criminally liable, you are liable. Friends, sources of criminal liability. Again, one small piece of legal proposition. Criminal liability always arises from a written law, from a statutory law. And the legislature must have empowered, either in the act itself, or it must have empowered a statutory body to charge someone for a crime. Otherwise, criminal liability does not arise. As far as doctors are concerned, criminal liability gets attracted thanks to the Indian Penal Code. There are some provision I will take you through. And there are some special laws. PCP and DT Act. If you do something, you don't do something, you attract criminal charges. Medical Termination of Pregnancy Act, Transplantation of Human Organs Act. So these are the acts where criminal liability is attracted. Let us see the Indian Penal Code. As far as negligence is concerned, most of the doctors only talk about section 304A, where due to criminal negligence, death is caused. But there are other provisions also. Even if no hurt is caused to the patient, section 336 can be attracted. When simple hurt is caused, section 337 is attracted. and when grievous hurt is caused, section 338 is attracted. Again, a small clarification. I have not come across any reported case where section 336, 337 or 338 has been attracted by medical practitioners. But it is there in the law book. Someday some policeman can use it. But yes, 304A, right from the British era, pre-independence time, doctors are being prosecuted under 304A and are punished also. One more small clarification. Nearly all the doctors who have been prosecuted under 304A and have been punished. Prosecuted, anyone can be prosecuted, but punished. Punishment has been given to only those doctors who were either doing cross-pathy, they were homeopath or Ayurvedic doctors and they went in for surgery, patient died, or it was outrightly quack. Otherwise, I have not come across an instance where a practitioner of modern medicine has been punished under section 304A of the Indian Penal Code. There are other offenses, 269 to 271, spread of infectious diseases. Even in these Epidemic Diseases Act has to a certain extent complemented this, but it is there in the Indian Penal Code. Section 274 to 276 regarding adulteration of drug, and section 287 can also be technically attracted because it is negligent conduct with respect to machinery. You have your laparoscopic machineries and so many machineries with which doctors work. Section 312 to 318 is still there in the law book. It must be removed because now we have the Medical Termination of Pregnancy Act, which is a special act dealing with this aspect. Of drugs happens to be a special act. You have to be very careful because there is something known as section 39 of the Criminal Procedure Code, which attaches a responsibility of everyone who comes across a section of offenses. There, the responsibility to inform the police, the magistrate, the statutory authorities is far higher. This is where in general criminal offenses, the police has to prove something. Here, if someone who has knowledge of this offense and does not inform the authorities, he or she has to prove why he does not do so. So of the CRPC goes, simple precaution that all doctors must take is that whenever they come across an adulterated drug, they must inform the police, do so in writing, and take preserve this copy of acknowledgement. Some offenses of the future: falsification of accounts. Yes, giving inflated bills, giving false bills. In fact, even fabricating records. These could be the offenses of the future. Again, a clarification. Till date, no one has been prosecuted under these provisions of law. Straight away to the Jacob Matthews and State of Punjab. Hello. A landmark judgment, friends, which was delivered in 2005 by the Honorable Supreme Court of India. The judgment was delivered by the then Chief Justice, Justice R.C. Lahoti, and 3 invaluable protections have been given to doctors. In fact, with my little knowledge and information of law, whatever I could search on internet, I have not found this protection in any other country of the world, only in India. People say that it's the parliamentarians who have great protection. Sorry. A member of legislature has a very limited protection. If the house of which that legislator happens to be a member is in session, only then there is a protection. And the protection is that the investigating officer has to write a letter to the presiding officer of the house and take permission before arresting. It hardly takes 2 or 3 days, maximum 3 days, and the permission is given to arrest the legislator. Friends, here for doctors, you have a protection which is there for at least 4, 5, 6 months. And in some cases, it has extended to 15 years. Cases filed in 2008, police has not been able to get a report in 2022 also. So friends, let us understand this invaluable privilege that doctors have been given. Before we come to the judgment, one more simple clarification. Criminal proceedings can be initiated at 2 places. One, we all know, police complaint. You can simply walk into a police station and complain, so and so has done so and so wrong. I want you to register a complaint. If the policeman sitting there does not register, you go to a higher official and you try to get that complaint registered. This is known as police complaint. Okay. There is another avenue where one can initiate criminal proceedings, and that happens to be a private complaint. So here, someone can straight away go to a magistrate's court, a criminal court, and file a complaint, and then criminal proceedings can start. This is known as a private complaint. So a patient can also initiate proceedings in similar fashion. He can go to the police station, file a police complaint, or he or she can go to a criminal court and file a private complaint. This judgment has protected doctors in both the places. First protection, in private complaint, the Honorable Court has said that the courts must not entertain any complaint of medical negligence if it is not supported by opinion given by an other doctor. So the Honorable Supreme Court is directing the lower courts that whenever a patient comes with a complaint of medical negligence, ask the patient to get medical opinion from another doctor, pointing out to the negligent conduct, pointing out to the rashness of the doctor accused of negligence. Friends, again, there is some dispute amongst lawyers, some difference of opinion. A few say this is mandatory, a few say this is not mandatory. I also believe the provision is not mandatory because the word used in the opening sentence, a private complaint may not be entertained. This may obviously gives a discretionary power to the courts. In fact, in the later part of the presentation, I will come to a very recent judgment given by the Supreme Court, where probably the Supreme Court is suggesting that this happens to be mandatory in nature. So friends, this is the first protection, first privilege that has been bestowed upon the doctors. Private complaint without a medical opinion should not be entertained. But it is this second privilege, which is of utmost importance, salutary provisions. The court has protected doctors in police complaint. Whenever a patient walks inside the police station to file a complaint of negligence against a doctor, the Honorable Supreme Court says that it is the duty of the investigating officer to obtain independent and competent medical opinion. Number one, the responsibility has been cast on the police. Neither the patient nor the doctor needs to do anything. But probably the honorable judges were well aware of how the police works in our country. They did not leave it to the discretion of the policeman. They have further said that you policeman, you investigating officer, you will get opinion from a doctor who is in government service. Number two, that doctor must be of the same specialty of the doctor accused of negligence. Don't get an opinion from any other doctor. If it is an orthopedic surgeon, get it from another orthopedic surgeon. And number three, the doctor whom you have approached to get medical opinion must be aware of the very basic Boehm's law. What is accepted medical practice? What is the standard of care that is expected by the medical practitioner? And only when that medical opinion comes and that medical opinion points out that yes, there is some negligence, then only can the policemen proceed against the doctor accused of negligence, not otherwise. Whatever little information I have, a mayor in Chhattisgarh, that too, he was of the ruling party, he expired and the family wanted to file a complaint. They filed a complaint. They wanted the doctor to get arrested. But with all that they have, they could not get a medical opinion and they had to wait for 4 months. By that time, this doctor got anticipatory bail protection from courts and all that. Salutary protection that has been given to doctors. And the policemen know this, and it is probably because of this reason that they want to charge the doctors under different provisions. Section 302, other sections they also apply so that they can arrest the doctor. I'm sure very senior members of the profession are here. Before 2005, the patient could just walk inside a police station, get the doctor arrested. Police used to come arrest the doctor, take it. After 2005, stray incidents have been there. And that all credit goes to this judgment. And even for arresting the doctor, the Supreme Court has said you can't arrest a doctor in a routine manner simply because a charge has been leveled against him. And I'm quoting from the judgment, unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigating officer feels satisfied that the doctor proceeded against would not make himself available to face the prosecution unless arrested, the arrest may be withheld. Don't arrest. You have charged. Fair enough, the doctor will face trial and the court will decide whether the doctor was negligent or not. Arresting, putting the doctors behind bar, don't do it in a routine manner. So friends, these are the salutary protections that are available. Two more clarifications. Number one, all these rights and privileges are available to doctors only in cases of criminal medical negligence, not otherwise. And protections are available to all qualified doctors. Whether you are a doctor practicing modern medicine, you have these protections. Where, when, and how to use this judgment? Whenever a doctor is threatened either by the police or by the public, copy of this judgment should be enough. And anyone who interferes with these three rights of the doctor is liable for contempt of the Honorable Supreme Court of India. Two very simple tips. Every doctor should keep a copy of this judgment of the Honorable Supreme Court handy. Two most powerful associations are here. A copy of the Honorable Supreme Court's judgment downloaded should be, please try to ensure that every doctor has in his or her cupboard. And obviously it should be produced before the police when they are acting illegally. So what are Supreme Court's view post Jacob Matthews? Is the Supreme Court on the same track or has the track changed? Two judgments, one of them landmark so very important, where 12 crore rupees was granted as compensation. Friends, even in that Kolkata case, the patient's husband had filed both a criminal case and a consumer case. And the Kolkata High Court as well as the Supreme Court, they dismissed all the charges of criminal negligence against the doctor. They granted 12 crores in compensation in a consumer case. But they said this is not criminal medical negligence. And let us hear what the court said in that judgment. It is, however, well settled that so far as the negligence alleged to have been caused by medical practitioner is concerned, to constitute negligence, simple lack of care or an error of judgment is not sufficient. Negligence must be of a gross or a very high degree to amount to criminal negligence. This is what the Honorable Supreme Court has said in the first judgment, which was delivered in Dr. Kunal Saha and versus Dr. Sukumar Mukherjee's case. Very recently, friends, 10 months back, in the case of Prabhat Kumar Singh versus State of Bihar, the trial court had accepted a complaint, a private complaint against a doctor without a medical expert opinion. And the Honorable Supreme Court sent back that matter to the trial court, saying that you must first, this is what the Supreme Court says, let us hear it out. At the same time, it is noticeable that the trial court had summoned the private respondents without insisting for medical evidence or examination of professional doctor by the complainant in support of his case made out in the complaint as required in terms of the exposition of this court in Jacob in so and so. So this was the recent case. All this points out that this is good protection to doctors. Unfortunately, friends, doctors are not aware, and even if some are aware how to enforce this, how to ensure that the policeman listens, follows this law, is a question which obviously is there before everyone, not only the leaders of IMA and API. Two simple tips that can help doctors: have excellent relationship with the local police. We have beat system in the metropole polices. Have excellent relations. It really helps. This is my personal understanding. As far as associations are concerned, please keep empanel a lawyer who is practicing in your district court. Friends, it's very important that you can empanel a lawyer in a high court or a Supreme Court, but when it is a police station, it is always the local lawyer who knows the local courts and the local police station who would be of immense help. So instead of individual doctors having a lawyer, come together and hire a lawyer, empanel a lawyer. Friends, everyone wants to be friendly with doctors. I, as a lawyer, I also want to be friendly with doctors. Judges want to be friendly with doctors, and policemen also want to be friendly with doctors. The reason is very obvious. It's my life. So if you can engage, empanel a lawyer, keep him, and whenever such instances come, it would be of great help to everyone. Friends, one guilt that we carried, we lost one doctor, we lost one life. And it was lost because possibly she was not aware of the legal protection that law has afforded to her. Institute of Medicine and Law with 5 national medical associations, we have come up with this Dr. Archana Sharma Med Legal Help Desk. We are going to provide free legal aid and advice to any doctor who is facing criminal medical negligence charges or harassment by policemen. Number 2, we have already started, and in fact, we have got calls from doctors One incident that the leadership of the medical fraternity is there. One incident just 3 or 5 days back from Dehradun. Intrauterine death is caused, and the police wants to register 304A. 304A will be attracted only when a person dies. The patient was, or the mother was all right, and they just wanted, they were harassing the doctor. Obviously from the help desk, we gave a call, but there was one small learning also. We did ask the local associations to give a letter to the local police, to the superintendent of police, in support of the doctors, and the local associations were under the wrong impression that until and unless the court or the police station asks for an expert opinion, we cannot give. I think this needs a clarification. The entire, or the leadership of the medical fraternity is there. That is why I am sharing some personal experiences, and they did not give. See, expert opinion is quite different from something where you go as an association in a democracy. So if something like this happens, one small simple tip could be that the local association should immediately send a letter to the SP's office, to the senior inspector of that police station. It is not an expert opinion. It should be very clear that 304, if you are applying to this case, you must first read Jacob Matthews case, and you must ensure that you act in accordance with Jacob Matthews case. Even these 2 lines are enough for the policemen. They generally will not do hanky-panky business. So friends, legal aid and advice we are offering. Second thing, we are training doctors. As already shared with you, the law is only this much. There is nothing beyond this. Jacob Matthews case has to be shown, and you have to read it properly, and then so we are training doctor volunteers who again will go back to the community and train doctors. The entire effort is that every doctor in this country must know at least this right, this privilege. A webinar. These doctors are going to have their list. We will provide them. Even we have our own faculties and speakers. We will provide them. Friends, a guilt that we were carrying, I was carrying, and let me confess this before the leadership of the medical fraternity. Whenever I was called to speak on legal issues, I never used to touch criminal issues. I was saying, this will, no doctor is going to be harassed because of this thing. And we used to have seminars and CMEs on prescription, advising, investigation, and diagnosis. Friends, this was more important. And one first seminar, Dr. Arulrhaj was there, and the husband of Dr. Archana Sharma came there. And this is what he said. It will just take a minute.
I would like to thank IML, Ravindra Mandal sir, Advocate Mahendrakumar Bajpai sir for such wonderful presentation. And I also feel that if my wife, Dr. Archana, had attended such a webinar, she might not have entered this suicide. So this lack of knowledge that we are well protected also creates stress among doctors. So I'll give big thanks to Institute of Medicine and Law that they are promoting this program of increasing awareness in the doctors. And
so friends, Dr. Archana Sharma, Med Legal Help Desk, in whatever way we can reach out to each and every doctor of this country, let us reach out. One more and the last aspect. Friends, when this judgment was given, before closing the judgment, the Honorable Court has said that we are only giving this judgment as a stopgap arrangement. The Parliament of this country must come up with laws. And why they have given the judgment? They have given reasons, great reasons. And those reasons are good even today. So let us make efforts to ensure that the union legislature passes an amendment, at least on 204. Whatever protection is given in Jacob Matthews, with all the learnings that we have of the last 17 years, that amendment should be made. This is my request. Thank you, friends, for listening patiently. Thank you, Dr. Arulrhaj.
I thank you, Advocate Bajpai sir, for educating on such an important topic, legal rights, privileges for doctors. We have with us Dr. Shyam Sundar, National President, API. I would now request Dr. Shyam Sundar to please speak a few words.
Thank you. Thank you, Dr. Arulrhaj, for the invitation. I can see Dr. Chabra here. So, I mean, it is a very important subject that you have picked up, and it is need of the day, because we doctors are generally not acquainted with what is going on, even though there are these Consumer Protection Acts has come into force for a long time, but we don't know how we can protect ourselves or how we can fight the cases. So I really congratulate Dr. Arulrhaj for having organized this, and I wish the Congress big success. Thank you.
Thank you so much, Dr. Sundar. Dear doctor friends, definitely this webinar would not be possible without the help of Dr. Arulrhaj, who could get two such big medical associations, IMA National and API National, on the same platform discussing this very important topic which Institute of Medicine and Law is presenting. On behalf of Institute of Medicine and Law, I would request API National and IMA National to please forward this message to all their local, state and city chapters to join us and register for the Dr. Archana Sharma Med Legal Help Desk. I would now like to introduce our panel members, Dr. K. Vijaykumar, National President, past National President, IMA. Dr. Marthanda Pillai, past National President, IMA. Dr. Vinay Agarwal, past National President, IMA. Dr. T. N. Ravi Sankar, past President, Tamil Nadu State Branch, IMA. Dr. Munish Prabhakar, Governing Body Member, API. Dr. R. M. Chabra, Governing Body Member, API. Dr. Jyotirmay Pail, Dean-elect, API. I would now request all the esteemed panelists to please discuss on this important subject.
May I ask a question from our learned speaker? Is he available now?
Yes, yes.
Yeah. Thank you. Thank you. Yeah. See, basically, as we have discussed the Jacob Matthews case in full details, there are a few things that I'm from Haryana and I am the past state president from Haryana as well as from the IAPI. So I represent both the organizations. In Haryana, the Haryana government has made a medical negligence board, which consists of the CMO, 2 specialists, president of the Indian Medical Association and one from the Ayush. So number one, that any police case that has to be registered has to go to the medical negligence board. Does this have a kind of, you can say every state has these kind of boards, or is it mandated by the law that these kinds of board has to be there, or the police can go to any doctors, government doctor to get the opinion? In Haryana, it is a mandatory thing to go to this board only to get the things, as has been made by the state government.
So, Dr. Munish, law and order happens to be a state subject as well as the center can also make laws. So here it is a local law which probably your state government has made. And I don't think it in no way dilutes what Jacob Matthews is saying. Okay, Jacob Matthews is also saying that an expert opinion should be taken before you proceed against a doctor. So what the state government has done, that they have further crystallized it into saying that go before committee only, and we are appointing a committee where doctors are there. So this is a very, very welcome step in your state. Other states could follow it.
Yes, Chabra, you can go ahead. Now, Dr. Jayesh has joined, our immediate past president. He can also join here. Now over to Dr. Chabra, please.
Yeah, I am Dr. R.M. Chavda, governing body member of ABA National and past chairman of the ABA Delhi State Chapter. Sir, we are talking about the medical legal case only to the doctors because two parties are involved, doctors as well as the police. One, we should organize such type of the seminar to the police also, because in the Archana case, the police didn't know about the law. That's why that happened. Due to the lack of the knowledge to the police. This type of the seminar should be in the police also, I think. What is your opinion?
Yeah, certainly these types of webinars should be organized. In fact, in the police training academy, they do sensitize the police officers about this topic. So, but when the policeman is hell-bent on doing mischief, things become very tricky.
Because due to the pressure of the political pressure.
In Archana Sharma's case, you ask any police havaldar, a small constable, he will also say 302 can't be attracted. So it is not that the policemen were not knowing 302. It was only that Jacob Matthews was coming in between, so they went ahead with 302.
Vinay, we would like to hear your views.
Yeah. I'm sure Institute of Medicine and Law and API, Dr. Shyam Sundar, Dr. Arulrhaj, Dr. Marthanda, President Dr. Sahajanand, Prasad, Singh, Dr. Lele, and many other dignitaries around. I have just to say that if you take Archana Sharma's case, I'm sure this webinar has been started from Archana Sharma, and we all are concerned about this case. My one point is that what kind of a help or assistance have been provided by Institute of Law and Medicine and Law to number one, Dr. Sharma. Number two is good that this activity has been started. I will also like to know that what are the points and what are the what are the changes you suggest in law, like we are looking for central law against violence and everything. Various states have different laws and which has different provisions. And because this particular repeated decisions of the Supreme Court has been repeatedly violated also at various times, particularly if you see in case of Archana also. How can we strengthen that Supreme Court judgments are implemented? And number two, how can we see that when 24, 23 states have already enacted a state law against medical violence, and maybe with different provisions, how can we ask for a central law? These are the two, three questions which I had, Mahendra Bajpai.
Sir, as far as getting the Supreme Court's order is concerned, Once the Supreme Court has given the order, everyone has to follow it. I just not recognize Dr. Vijaykumar. Sir, sorry. Dr. Vijaykumar, sorry. Sir, when Dr. Vijaykumar was president, in last months, there was one case that had happened where 104A was not properly, or rather the doctor was arrested. Dr. Narendra Saini happened to be the secretary at that point in time. Even at that point in time, I had given an opinion that a contempt must be filed in the Supreme Court. This is contempt of the Supreme Court's order. This is not a law that has been made by the legislature. File one or two contempts, sir. You all have so many friends amongst lawyers and you get so many cases from different states. Let one or two policemen let them be punished. Otherwise, policemen know law, but when they are under some pressure or some influence, they break it.
No, I find what Mr. Bajpai you are saying. I mean, I as a medical activist and a past national president have been repeatedly saying that, and we all know that a contempt case should be filed. Whether it is IMA, whether it is API, or whether it is, Institute of Medicine, or otherwise other organizations which are concerned about this, right? I mean, I don't even know a simple one case where a contempt petition has been filed in the Supreme Court or otherwise. They all are waiting. They are all asking for the situation to come. It is 2.5 months there, and I personally feel that we should be aggressive on that, and particularly body like yours, which is very active and which is very organized. And you, as lawyer, medical body, should take this to file a contempt petition in the Supreme Court.
Sir, Dr. Narendra Saini is there. I'm sorry, Dr. Vinay. Dr. Narendra Saini is probably there. At that point in time, I had to give this advice. I don't know what happened, but it did not fructify.
Sir, you are misunderstanding. I get this advice. We all know that a contempt petition should have been filed.
So why you are not filing?
While we are using as a Dr. Archana Sharma legal aid help desk, right? Now, as such, this Institute of Medicine and the Law, I just want to, my knowledge to that what Institute of Medicine and Law has particularly done in this case.
Sir, we are an educational.
I personally feel the IPA is still waiting, API is still waiting. But what this institute has done, you as lawyers, have you filed on behalf of Sunit Upadhyay or anybody else a case wherever, because you are more knowledgeable, you are very senior, that a case in the Supreme Court as a contempt case?
Sir, we have already advised him and we are advising other bodies. Now someone has to come forward and file a case. That sir, Institute of Medicine and Law has nothing to do with this. We are an educational body and we are limited to education. This becomes a professional thing and we have been ready. On a personal level, I have been ready to help doctors or associations. But someone should come forward, someone should file it.
And I don't take my, aspersions or suggestions otherwise, but I still feel that while we are using a name to call it a Archana Sharma help desk, we should have something for Archana Sharma's case. That is what I'm asking you. I mean, I suppose absolutely. Tomorrow 10 bodies like yours or IMA also or API also creates this desk because Archana Sharma is a sensitive issue. But finally, outcome is that we all are educating, but we are all none of us is acting. That is what I'm seriously saying.
So, sir, what do you expect us to do as an educational institution? We are not an association of doctors. Number one, we are an educational institute. What we thought fit, we are doing under this help desk. Number one, we are giving legal aid, and we have already given. Number two, we are trying to train volunteers. We are trying to train doctors. We are giving them whatever knowledge is required by them. You have
Perfect.
just now heard Dr. Sunit Upadhyay. It was not only our responsibility, sir. If one Archana Sharma
I-
committed
you have-
suicide, isn't this the responsibility of many others? Yes,
Bajpai
Sir,
sir,
we do
sir,
say as
sir,
an educational
Yes.
institution, we failed
Yes,
somewhere.
Vinay.
That's
I-
Vinay,
why
your point is well taken up. Your
You are
point
taking
is well
I'm not
taken up,
passing
Vinay.
expertise.
Your point is
I'm
well
not passing
taken up.
expertise. I'm saying while we are using the name as a help desk, we should be sensitive enough to see that these cases are filed. Otherwise, 4 such bodies will make a Dr. Archana Sharma help desk. Even IMA can make, API can make Archana Sharma help desk for something or the other. But it is not fair to use the name, but not being able to either suggest or ask or see that a contempt petition has been filed. This is what my observation is. Right?
Yes,
Sorry
it will
for
be
my
sir,
taken
if
remarks.
I
care,
may,
Vinay.
sir,
I'm known for my
It will be
candid
taken
remarks.
care. Yeah, now
Yeah.
we'll hear the views of Dr. Marthanda.
Dr.
Marthanda,
Arulrhaj, if you'll excuse me, this is Ravindra Mangal from the Institute of Medicine and Law. Just
Yeah.
to add to what Dr. Agrawal has just said,
Please, please, please.
like we have already communicated to all the associations in writing. There are 3 services that we are offering under the Archana Sharma Med-Legal Help Desk. One is training the doctors so that they can train other doctors on this sensitive issue, on this protection that is available to all the doctors. The other is holding as many webinars as possible, which are absolutely free of cost. We are not charging anybody anything for holding this webinar or for training the doctors. And the third service is filing of contempt petition in the Supreme Court, absolutely free of cost, no charges. If any case, any more cases like this come up to us, we have already got many inquiries over emails, which we have already addressed individually. So as an organization, we are doing all that we can for doctors. Now it is for the doctors to come forward and make use of these initiatives. As far as the sensitivity issue goes, we already have a written permission from Dr. Sunit Upadhyay, who is the husband of Dr. Archana Sharma, to use the name so that people are able to identify, doctors are able to identify easily. We are not here to use anybody's name. It was only an
Perfect.
effort on the part of the organization to be able to save a life of a doctor who is saving lives of so many patients.
Thank you,
Perfect.
Mr. Ravindra,
I
for your
got you.
clarifications. Vinay, we are diverting. We will listen to Dr. Marthanda Pillai. Over to Pillai. You are not audible, Marthanda Pillai. You will have to unmute yourself. Okay. Pillai, we are not able to hear you. Whether you have unmuted yourself?
Dr. Arulrhaj, he is not on mute.
Then
Yes,
why
yes,
voice
yes.
is not coming?
Yes.
PPTs are seen.
Hello. Yes, Dr. Arulrhaj.
Yeah.
See, I'm sorry. There was a little diversion on my this thing, but I personally feel it's a very good initiative which has been taken by both the organizations, including Institute of Medicine and Law. And
Thank you, Vinay. Thank you. We always know your good wishes.
And my two
so
important things which I just want to say, that 2 things are very, very important. One is that this repeated Supreme Court judgments, including the Jacob Matthew case versus Punjab in 2005, and also repeated assertions by Supreme Court in various judgments that it should be strictly followed too. This should be, at least we as a movement or as something, we should be able to reach to every police officer or every state in strictly. And number 2 is we should all work together and particularly organization like Institute of Medicine Law are required in educating medical professionals, particularly to see that they are able to create a movement, and this movement which should be at least looking for a central act and or strictly getting this particular state act implemented properly. And as far as Archana Sharma case is concerned, I'm sure we are lagging behind somewhere. And as far as I know, Indian Medical Association has filed a case, I mean, in Supreme Court, but I do not know the exact case what it is. But I'm sure some few things should happen in this case. We feel sad, we feel frustrated, and this is what it is. Thank you very much.
Thank you, Dr. Agarwal, for your comments. I now request Dr. Pillai to please start his presentation.
Hello.
Dr. Pillai?
Pillai, there is some issue in your PPTs and your audio. I think you are reading, but we are not hearing.
Dr. Pillai, if you can increase the volume on your system, that might help.
Can I ask one question? He's
Wait, Chabra. Now we are on the supporting in Dr. Marthanda Pillai.
Okay.
We'll definitely listen to you. Don't worry.
Okay, sure.
The mic is all right, Pillai. Can we listen to Vijaykumar by the time you set right your audio side? Okay. Now over to Vijaykumar. Vijaykumar.
Yes, sir.
I'm so happy that our advocate mentioned two key names. One is Vijaykumar, another is Ravi Shankar. It's a pride to the medical profession. Shiny also. Both of you got, law qualification in addition to medicine and serving a lot. We would like to hear your view here. This is restricted to two things. One is the procedure for prosecution of doctors and what are all the legal rights or safety doctors have, and what do you think about healthcare protection?
Sir, first of all, I should congratulate Dr. Arulrhaj, Institute of Medical Law,
Medicine and
Law, IMA and API Movements of India for organizing such a wonderful seminar. So problem with IMA is always we start. I don't want to mention anything about APA. We will start certain things which will not be followed. I am sure, I am very happy that Bajpai has mentioned my name. At that time, while I was the national president in 2012, I had a consultation with Bajpai, and Ravi Shankar also was with me, and Shiny was also instrumental in that. We contacted them, and clear-cut instruction was given to us, IMA headquarters, by our great man, Bajpai, who has given an excellent oration today. And he has instructed us to request the Government of India through IMA as well as Medical Council of India, so that suitable amendments can be brought up in the IPC as well as the CRPC. It should be brought as per the direction of the Jacob Matthew case, and one of the direction is that. But we contacted and we have requested, we contacted law people and we have done everything. But that couldn't be materialized because the lack of follow-up in the subsequent IMA years. Please, definitely IMA should contact, once again, headquarters should be in contact with Government of India along with the National Medical Commission, so that there should be an amendment and it should be made as a law so that people, police people, legal people, doctors may not be aware, all may not be aware about Jacob Matthew case, and it should be made as a IPC inside the IPC book, which will be in the table of every police officer from top to bottom, so that it become a statutory body thing to listen. In 2012, we have contacted and we have made this thing which couldn't be materialized. Now we have to reinforce the same thing to get an amendment through IMA headquarters, which is the largest professional body, as decided by Bajpai. I don't know whether IMA headquarters is following it or not. It has to do it if it is not doing it. That's my little contention here. So another thing is, the Supreme Court has given a clear-cut and very good judgment. I am sure Bajpai also will be accepting with me that we can knock the door of Supreme Court, that your judgment, which was giving protection to our profession, is not made as a law, made as a statute law in IPC or CRPC as per your instruction. Hence, we would like to do it, and an order can be obtained from Supreme Court, which will be sent to the Government of India, Legal Department and all others, so that it will be a permanent structure for the legal action against the doctors. See, at that time, in Tamil Nadu, we contacted the police department and we got a direction on that line, that is
Mukherjee.
Mukherjee, that Ravi also was involved in that. So we got a clear-cut direction. So it is there in every police officer's book, but only a circular was sent. It is not a permanent one. That's why we request the IMA headquarters to make it as a document in the IPC. Then in Karnataka also they got similar version from the police department. That has to be followed in each and every state. Contempt of court is a must for Archana Pandey case, Archana case. Action against the erring officer should be a must. We are failing in, we are lacking on it. Just because we have transferred, that is not the answer. IMA should be more vigilant and it should be vibrant against this case, because unless IMA does something for this death of Archana Pandey, she wanted something to be done and she has given some advice to the medical profession. So it is our duty, bounden duty to do it. I request all the IMA leaders, including past, present, sitting and future leaders, to take it as a challenge to get amendment in the CPC, CRPC as well as IPC. Then only Archana as soul will rest in peace. That's my humble request. Please do it. Thank you, sir. Thank you once again. I request Bajpai sir to continue the same friendship as well as this thing trend in. See, at that time he has sent lakhs of messages, short messages to all IMA members. I remember even now that I have taken screenshot and kept it everything, and that was the wonderful service by Medical Institute of Medicine and Law, and it should be continued in future also. We had several consultations. I went to Mumbai and we met at the hotel, which was just in front of the airport, and we had several discussions there, and I want the partnership of this partnership to continue forever, and it should grow in strength and might. Thank you.
Okay.
Thank you so much, Dr. Vijaykumar, for your wonderful views, and I congratulate you to emphasize on the fact that IMA should do such programs more, and IMA should understand the importance of medical knowledge and support for Dr. Archana Sharma.
Pillai, you are ready, Pillai? Pillai, no. Okay, then Ravi continue.
Thank you, sir. Thank you, Arulrhaj, sir, and thank you, IMA, for giving me this opportunity. Thank you, Bajpai, recognizing me in this big audience. And 16 years have gone. The request for a statutory law or an executive instruction has not been taken up, or it has not been done. I think the flaw lies on the medical community. Dr. Vinay was pushing the onus on you to the Institute of Medicine and Law. Now I am again asking Bajpai the roadmap to make this possible. The Law Commission is not active. There is nobody in the Law Commission and no chairman in the Law Commission. Where do we start it? How do we take it forward? And what is it that has to be taken forward? I think Bajpai, you should be able to provide us the information, what it has to be and what are the amendments or additions that has to be in the IPC or in the Criminal Procedure Code. If you give a timeline, take 15 days or 4 weeks, give us the draft, what it has to be done. We should ask all the association to take it forward. You give us the roadmap, where we start, at which point where we are going to meet the final. And if you give a timeline, I think Dr. Arulrhaj sir will be able to do that timeline of another 45 days or 60 days, so that the present tenure of the president and our Secretary General also will end with a very, very peaceful practice for the medical committee. We keep talking, like Dr. Vijaykumar said, we started, we don't follow it. We have to follow it in the right way. The roadmap has to be given by you. And what is it that we wanted for the medical community has also to be given by you, because you are not only an educator, you are a reformer for the medical community also. Thank you, Bajpai.
Thank you, Dr. Ravi Shankar.
Pillai, are you ready?
Mukesh Yadav has also joined us.
Pillai?
Welcome you.
Thank you.
Dr. Pillai, if you are ready with your sister, we can start with you.
वाटर है ना, तो वाटर की इवेपोरेट होता है तो कोल्ड हो जाता है स्किन. जस्ट सीधा ड्राई हो जाता है. ह्यूमिड में जाए. हमारे को जैसे आदत पड़ गई है ना, तो ड्राई नहीं कर जाता, ह्यूमिड ना ह्यूमिड.
Then we will listen to the Chabra was raising his hand.
Yeah.
You can unmute yourself and say.
Sir, my question to the Dr. Mr. Bajpai. We are writing the thing that this prescription is not for the medical legal purpose. Does it serve any purpose?
No, absolutely no. In fact, it acts as a reminder to the patient that you can sue this doctor also. Okay. It is counterproductive.
Okay. So we should not write like this. Okay. So in my opinion, the IMA is doing so much work. So other associations should empower the IMA, because IMA is a big concern, because Dr. Vinay Agarwal and all the past presidents are doing well. They are having a very medical legal cell in the IMA. So when we should empower the IMA to lay down so many things for the medical legal cases.
Isha, are there any questions from the audience in the chat box?
Just give me a moment, Dr. Arulrhaj.
Yeah. If there are any questions, we can include that also.
No, sir, there are no questions in the chat box.
Okay. Now we are waiting for Pillai's viewpoints. Then we can close it up.
And one question more. Can a patient directly sue for the fake degree on the doctor if he is registered under the MCIU?
Patient wants to sue a doctor?
Yeah, on the fake of degree, because he is registered as well on the hospital as well with the MCI.
So why only a patient? If you have done a fake degree, anyone can sue you. Anyone can bring it to the cognizance of the police, And then it will be between police and the doctor if it is a fake degree.
Who will decide? The DMC will, MCI will decide whether it is a degree fake or not.
Yeah, yeah.
Okay.
Your regulator will decide.
Pillai, can you communicate without even PowerPoints? Pillai, Marthanda Pillai, even your PowerPoints are not working. You can, through your mobile, you can click the link and join us. Give your views. I think there are no questions and Pillai is not able to join us. We have listened to everybody. We should thank all the leaders of IMA and APA for participating, as well as we should thank Mr. Bajpai for a very nice oration he has delivered. And Isha and her team, Ravindra and all, have to be, congratulated and thanked. Now the message here is mainly two. The message for the medical profession is we should continue to follow. There are many reasons which for the lack of follow-up, which all of us know, elders, but we need to push it, see that things are happening. Number two, can we, any one of us, file a contempt of court petition against the legal people? That is the two question. We wait for APA and IMA, they have their own restrictions. That is a number two. Number three, Ravi Shankar gave an excellent point to Mr. Vajpai. That is, he has to tell us, these are all the things you should get it. What changes, what modifications to IPC and CPC has to be there, and the healthcare protection also, what we need to input. I already shared my document to him. He can fine tune it and give it and see that we'll push it with the government through the association or our personal relations also. That will be the greatest, homage that we can do to our colleague, Dr. Archana Sharma. And we should do that together, definitely. The Institute of Medicine and Law, I always love it because it has two components. One component is medicine, another component is law. And this never happens in India. This has happened. Let us utilize it positively, and with thanks, we will close it up. Thank you all very much. Thank you very much.